December 2nd, 1993.
He wrote one of the most controversial decisions ever to come out of the Supreme Court.
We put the abortion cases on, and that was a mistake because we just didn't realize that we had a bear by the tail, so to speak.
We'll hear arguments in number 18, Roe against Wade.
These cases come here, they have to be decided, somebody has to write them.
Mr. Chief Justice, and may it please the court.
Roe against Wade was decided on, I like to think, on constitutional grounds.
Mr. Chief Justice, may it please the court.
I've been under attack for 20 years on Roe against Wade. I suppose I'll carry it to my grave.
Tonight, anatomy of a decision. Roe v. Wade.
This is ABC News Nightline. Reporting from Washington, Ted Koppel.
It may well be that most of us know more about the Central Intelligence Agency than we know about the Supreme Court. Sitting justices rarely grant interviews and never talk about cases that are before the court. Cameras are only rarely allowed into the building and never when the court is in session. Not even still photographs are permitted of the justices on the bench, and no one is allowed to bring a tape recorder into the courtroom. And yet, the Supreme Court itself has for years been taping its own sessions. In recent weeks, for the first time, the court has granted permission for the broadcasting of those tapes. They provide, as you might expect, quite a remarkable insight into some of the most controversial cases of our time. A case, for example, like Roe versus Wade, a case which ultimately led to the legalizing of abortion across this country. It is excerpts from those arguments that we will play for you tonight. We were also granted permission to show you the inside of the court. And Justice Harry Blackmun, the man who wrote the Roe v. Wade decision, agreed to talk with Nina Totenberg of National Public Radio and me. What a controversial decision it proved to be. From the very first and to this very day, Roe v. Wade has provoked anger, passion, and a sometimes frightening degree of moral certitude on both sides. I'm joining my colleague Nina Totenberg on what is actually her turf, her beat, the Supreme Court, and we are standing in front of the open doors of the Supreme Court itself, and back there you can see arrayed some of the chairs of the 9 justices who sit on the bench of the Supreme Court. On the day that Roe v. Wade was heard for the first time, Nina, you were here.
The courtroom was jam-packed, but it's interesting. I don't think that I or perhaps anyone else in the courtroom thought we were hearing the landmark case that would, in effect, legalize abortion in America. Even most pro-choice advocates thought that at best, this would be the beginning of a long odyssey of cases. At issue was a Texas law that made it a crime to have or perform an abortion except to save the life of the mother. Even in cases of rape or incest, abortion was illegal. And a Texas woman, using the pseudonym of Jane Roe, wanted an abortion and was asking the Supreme Court to strike down the Texas law. That challenge ended up here in this courtroom.
We'll hear arguments in number 18, Roe against Wade. Mrs. Weddington, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the court. In Texas, the woman is the victim. The state cannot deny the effects that this law has on the women of Texas.
Sarah Weddington was only 26 years old when she stood at that lectern. She had never argued a case in the Supreme Court. Indeed, she had precious little legal experience, but she did have a passion. 4 years earlier, this daughter of a Methodist minister had become pregnant while not married and had had to go across the border to Mexico to get an abortion. No one knew about that experience, not her parents or her friends or her colleagues, but it was in her mind as she argued this case.
A pregnancy to a woman is perhaps one of the most determinative aspects of her life. It disrupts her body, it disrupts her education, it disrupts her employment, and it often disrupts her entire family life. And we feel that because of the impact on the woman, this certainly, in as far as there are any rights which are fundamental, is a matter which is of such fundamental and basic concern to the woman involved that she should be allowed to make the choice as to whether to continue or to terminate her pregnancy.
Justice Potter Stewart pressed Weddington about the constitutional basis for her argument.
Mrs. Weddington, so far on the merits, you told us about the important impact of this law, and it's made a very eloquent policy argument against it. I trust you are going to get to what provisions of the Constitution you rely on.
In the lower court, as I'm sure you're aware, the court held that the right to determine whether or not to continue a pregnancy rested upon the 9th Amendment. I think the 14th Amendment is equally an appropriate place. Under the rights of persons to life, liberty, and the pursuit of happiness, I think in as far as liberty is meaningful, that liberty to these women would mean liberty from being forced to continue the unwanted pregnancy.
You're relying in this branch of your argument simply on the Due Process Clause of the 14th Amendment?
We had originally brought the suit alleging both the Due Process Clause, the Equal Protection Clause, the 9th Amendment, and a variety of others.
And anything else that might have...
Yeah, right. You know.
Do you have any compassion for the nervousness of an attorney who comes in and argues before the Supreme Court for the first or maybe the second or third time?
Well, it's a daunting experience in some respects. After all, one is out there standing alone on the podium and these 9 black-robed figures almost leaning over and making noises at him, it's not easy.
Will that take you right up to the time of birth?
Obviously, I have a much more difficult time saying that the state has no interest in late pregnancy.
Why is that?
After Stewart, Justice Byron White moved in aggressively, asking just how far a right to abortion would go.
I think it's more the emotional response to a late pregnancy rather than it is any constitutional.
Response by whom?
I guess by persons considering the issue outside the legal context. The Constitution, as I see it, gives protections to people after birth.
Thank you, Mrs. Weddington. Mr. Floyd?
Remember now that no one knew how important this case would end up being. It was, in fact, so low profile that the Texas Attorney General didn't even show up for the argument. He sent one of his subordinates, Jay Floyd, to argue the case. And of the 4 principal lawyers in the courtroom that day, Floyd was the only man.
So he was there with 3 women, and I think was self-conscious about it. And in some respects, one could say he was, because of his self-consciousness, he was outmaneuvered and outclassed. I would have felt uncomfortable, too, as he did.
Mr. Chief Justice, may it please the court, it's an old joke, but when a man argues against 2 beautiful ladies like this, they're going to have the last word.
The joke fell flat. After an embarrassed silence, the justices began their questioning of Texas Assistant Attorney General Jay Floyd.
What procedure would you suggest for any pregnant female in the state of Texas ever to get any judicial consideration of this constitutional claim? I do not believe it can be done. There are situations in which, of course, as the court knows, no remedy is provided. Now, I think she makes her choice prior to the time she becomes pregnant. That is the time of the choice. Maybe she makes her choice when she decides to live in Texas.
And every now and then, of course, things get so very tense that it's a good idea to either change the subject or to throw some wisecrack into the proceedings. It may sound out of place, but it is a little helpful.
After the argument was over, the justices went to their secret conference, as they do each week. No one else is present, no law clerks, no minions, no secretaries. The justices take their own notes. They discuss the cases they've heard, and they vote. In December of 1971, they voted tentatively to invalidate the Texas law, and Harry Blackmun was assigned by the Chief Justice to write the opinion. But a funny thing happened on the way to writing that opinion. Blackmun began to have reservations. not about the case, but about the fact that it had been decided by a 7-man court. You see, just before the beginning of the term, 2 of the older justices had suddenly retired because of ill health. The court decided to go ahead anyway and hear the Roe case. But now Blackmun and Chief Justice Burger, both Nixon appointees, wanted the case put over for re-argument before a full court that would include 2 new Nixon appointees to the court. The other justices were furious, suspecting that the traditions of the court were being manipulated to change the outcome of the case. But Blackmun prevailed.
This is ABC News Nightline, brought to you by IBM.
How can IBM help you these days? Ask Santa Fe Railway.
Our growth is built on meeting customer expectations. IBM helped re-engineer our systems to make it happen.
Ask Dixon Ticonderoga.
For disaster recovery services, you need to pick someone you can count on. IBM was the obvious choice.
Ask Nintendo.
IBM helped automate our warehouse. We just shipped 1 million new games in 1 weekend, our most successful launch ever.
You want fast results? Talk to us. There's never been a better time to do business with IBM.
The new Accord EX Coupe. There's more horsepower. Handling and comfort are perfectly balanced. It has dual airbags and anti-lock brakes. We've taken it about as far as you can go.
When the next term opened, Roe versus Wade was back in the Supreme Court. Texas replaced Jay Floyd with his immediate superior, Robert Flowers, and Sarah Weddington, knowing she had faltered the first time on the constitutional questions, sought to repair the damage.
Certainly we cannot say that there is in the Constitution, so stated, the right to an abortion, but neither is there stated the right to travel or some of the other very basic rights that this court have held are under the United States Constitution. There is a great body of cases decided in the past by this court in the areas of marriage, sex, contraception, procreation, childbearing, and education of children, which says that there are certain things that are so much a part of the individual concern that they should be left to the determination of the individual.
Mr. Flowers, it is impossible for me to trace within my allocated time the development of the fetus from the date of conception to the date of its birth. But it is the position of the state of Texas that upon conception we have a human being, a person within the concept of the Constitution of the United States and that of Texas also.
Flowers, arguing against abortion, was challenged by the justices on when a fetus becomes a person. Justice Blackmun began that round of questions.
How should that question be decided? Is it a legal question, a constitutional question, a medical question, a philosophical question, a religious question, or what is it?
Your Honor, we feel that it could be best decided by a legislature in view of the fact that they can bring before it the medical testimony, the actual people who do the research. But we do have...
You think it's basically a medical question?
From a constitutional standpoint, no, sir. I think it's fairly squarely before this court. We don't envy the court for having to make this decision.
I want you to give me a recognizable medical writing of any kind that says that at the time of conception, that the fetus is a person.
I do not believe that I could give that to you without researching through the briefs that have been filed in this case, Your Honor.
Flowers ended with a strong plea for the unborn.
This court has been diligent in protecting the rights of the minorities. And gentlemen, we say that this is a minority, a silent minority, the true silent minority. Who is speaking for these children? Where is the counsel for these unborn children whose life is being taken? Where is the safeguard of the right to trial by jury. Are we to place this power in the hands of a mother and a doctor?
Thank you, Mr. Flowers. The case is submitted.
At the end of the second argument, the justices, this time 9 of them, returned to the conference room and voted.
The Supreme Court today ruled that abortion is completely a private matter to be decided by mother and doctor in the first 3 months of pregnancy. The 7-2 ruling to that effect will probably result in a drastic overhaul of state laws on abortion.
Abortion would, in effect, be legalized in America. And you'll be interested to know, Ted, that among those 7 were 3 of the 4 Nixon appointees. The Chief Justice, Warren Burger, Lewis Powell, and of course the author of the opinion, Harry Blackmun.
You've told me a fascinating story about Lewis Powell, and I hope you'll tell our audience now. One tends to think of these justices as being totally removed above the issues that they are deciding here, but Powell was very much moved by something that had happened to him many years before.
Well, as we all know, judgment is the result of experience and what you learn from books and law school and past decisions. And Lewis Powell, shortly after he retired, told me that one of the things that had influenced him strongly in his decision to join Roe versus Wade was an experience he'd had when he was a relatively young lawyer, a senior partner in a Richmond, Virginia law firm. And he got a call one night from one of his office boys and went back to the office to find this young man in tears, distraught. The kid was about 17 years old, and he was living with what Justice Powell referred to as an older woman. She had become pregnant, and acting on her instructions, the office boy had aborted her using a coat hanger. She had hemorrhaged, and he had run to Justice Powell, then Lewis Powell, for help. The 2 men then went to where the couple lived, and they found her dead. And Lewis Powell had to turn his office boy into the local prosecutor, but he persuaded the prosecutor not to bring charges on the grounds that the office boy was so young and was acting on someone else's instructions. And when Justice Powell told me this story, he said, ever after that, I thought this was not the business of the government. This was the business of private choice.
And so Lewis Powell, one of the 7 justices who voted to make abortion legal in the United States, and what followed, of course, some 21 years of political infighting, demonstrations, bitterness that continues to this very day. When we come back, we'll be talking to Justice Harry Blackmun about the aftermath of Roe v. Wade.
Hey, Ace is a place in Oregon, Illinois, and here's why.
You get more bang for your buck.
Like this Ace 24-piece socket and bid set, just $8.88. Plus stock up on Energizer batteries, all popular sizes.
Hey, Ace is America's place for better values.
It kills the germs that cause bad breath. It fights plaque. It battles the gum infection, gingivitis. It's Listerine antiseptic. It's there to protect you.
Difficult decision at first. But over time, it gets a lot easier to live with. Acura. Some things are worth the price.
Next time, how to do your holiday shopping without leaving home.
Also actors Mel Harris and holiday music from Harry Connick Jr.
On the next Good Morning America.
Look what a nickel buys at Walgreens. A box of 50 mini lights is only $4.99, and the second box is just a nickel more. Buy 1 roll of gift wrap for $2.99, get a second roll for a nickel. Buy a bonus pack of replacement bulbs for $1.59, your second pack is only a nickel. And you can get a second set of regular or supersized prints for just a nickel each. Have a very Merry Christmas from Walgreens.
Here it is, the new
1994 Plymouth Voyager, our safest minivan ever. And now with air and automatic, amazingly affordable. As low as $242 a month. Plymouth Voyager, the #1 selling minivan in this town for 9 straight years. See your local Chrysler Plymouth dealer today.
Table for one, please.
No one likes a messy umbrella.
Clark, for one, please.
Table for two would be faster.
No, thanks.
That's why Totes umbrellas have a special invisible silicone coating, so you can shake your umbrella virtually dry.
Hi, one, please.
Instantly.
You know, a table for two would be faster.
Totes umbrellas shake virtually dry instantly.
Some of these cases are tough. The public doesn't realize that these cases come here, they have to be decided, somebody has to write them. And frequently, not always, but frequently, it's an unpopular position. And the court itself is criticized, but that's part of the job, and all of us catch those undesired opinions to write every now and then.
You know, you wrote Roe versus Wade when you were a relatively junior justice. I think you'd been on the court 3 years. I think you started work on it after less than 2 years, in fact. How did that feel? Did you know what a momentous decision it was?
Well, it wasn't very easy, and it was an emotional, highly divisive issue.
Mr. Justice, there's sort of a legal conceit that a Supreme Court decision is dispositive. Of course, in the case of Wade v. Roe, it hasn't been. It continues to boil in the body politic out there. How does that make you feel? I mean, does it make you feel that in some sense you were going contrary to the will of the public, or is this just a very vocal minority that you see out there?
Well, it's certainly vocal on both sides. I think, and this is just my own personal reaction, I think the basic issue is decided so far as the law is concerned. And where the tumult to which you refer now arises is in the legislatures and things that bear on state statutes and the like. But Roe against Wade was decided on, I like to think, on constitutional grounds. And it was a constitutional decision. It was not one based on morality or all the rest. And I think from a constitutional point of view, the issue is settled.
And yet, there has been the perception from the outside looking in that depending on who is elected president, depending on who gets to appoint successors on the court, that maybe the issue has not been disposed of.
Well, that may have been true in the last election, certainly, because there were close to enough votes to overrule Roe against Wade. And, but the court has never done it. I think it's 5 times that the last 2 administrations, specifically through the Solicitor General, asked that Roe against Wade be overruled and attacked it vigorously. Trying to shame me, I suppose. But though the votes might well have been there, they have never been exercised. And there it is.
Was I mistaken, or did I see a slight smile of satisfaction there a moment ago?
Well, I've been under attack for 20 years on Roe against Wade. I suppose I'll carry it to my grave. I'd like to think that I've written in other areas of the law some rather significant decisions, but one gets tagged with one, and there it is.
What's that fragrance you're wearing?
Exclamation! Make a statement! Without saying a word.
At Ford Motor Company, we're already building vehicles that meet California's strict emission standards for the late 90s. We're the first U.S. manufacturer to build a car with CFC-free air conditioning. And we'll soon have a fleet of electric vehicles on the road. For us, designing quality cars and trucks means keeping an eye on the big picture.
At Ford, we understand that the quality of the environment is one of our greatest responsibilities.
Ford Motor Company, quality is job one. It's working.
Of all the credit cards out there, only one has Smart Rate, now as low as 14.9% and no annual fee. Discover Card. It's a better deal. It pays to discover. This holiday season, while you're shopping, we'll be dropping $5 million in the Discover Card Big Payback. Now, every time you use your card, you're automatically entered in our $5 million sweepstakes. It pays to discover the card with the big payback.
You know, there's nothing more fun than a vacation at sea. You can lounge in the fresh air, visit romantic ports, enjoy fine dining, great shows, pampered service. I love it here. There's so much to do.
Holly, Hal, hi, Kathy.
Hi, Richard. What are you doing here?
Having the time of my life.
Oh.
Yay! If my friends can see me now.
Take a 3-, 4-, or 7-day vacation on Carnival, the most popular cruise line in the world.
I love this ship.
It is an entirely new class of luxury automobile, created to a higher standard. So responsive, its advanced V8 Northstar system makes passing and merging virtually effortless. And so spacious, it accommodates 6 passengers in complete comfort. It is a combination of qualities you've never seen before. Yet a single drive will make you wonder why you ever settled for less. Introducing the all-new DeVille Concours by Cadillac, creating a higher standard.
Tomorrow night, Nina and I will talk to Justice Blackmun about serving and growing old on the highest court in the land. That's our report for tonight. I'm Ted Koppel at the U.S. Supreme Court in Washington. For all of us at ABC News, good night.
Nightline is a presentation of ABC News. More Americans get their news from ABC News than from any other source.